Good morning, Sudhir bhai.
Good morning, Geet. Thank you very much. And before I ask you any questions, let me tell you that you are the most deserving candidate for the FOGSI Vice President this year election. And actually, the members of FOGSI would be benefited and not you. So I wish you all the best, and I am always with you, and all the FOGSI members are with you. So let me ask you the question regarding the medical legal queries.
Sir, let me say first of all, Dr. Sudhir Shah is senior most gynecologist in Rajkot. He was associate professor at Sayaji Hospital in Vadodara, and he authored a book on NDVH Made Easy, published by JP in 2004, and 5 other books were also authored. He has given multiple guest lectures, keynote addresses, and oration at state and national level. And he is national corresponding editor of FOGSI Scientific Journal, that is Jogi, and one of the chairman of FOGSI Media Committee. So welcome, sir.
Thank you very much, Geet, for the so kind words. And my queries are: what is to be done if a doctor receives the legal notice?
Yes.
Because many doctors, when they get the legal notice, they are very stressful.
Yes.
And what precautions to be taken in replying such notice?
Right, sir. So basically,
and the third question is that how to identify a good lawyer in our own city, because we don't have a good lawyer like you in every city. So
right,
how
sir.
to do that?
Right, sir. So basically, sir, notice can be received. Notice, what is the meaning of notice? So notice means that when patient communicate her or his intention to sue a doctor, that is notice. That can be oral notice, that can be on phone, that can be through fax or email or by register ready letter. Now, notice are of 2 types. One, it is when it is received by patient from the patient or their advocate, and another if it is received from some of the forum, that is consumer protection fora or for some commission. So that are the 2 kinds of notice. Now, when you receive notice from the patient or advocate, it is not mandatory to reply by law, but it is advisable that even then you should reply so that they should not feel that you are avoiding. And second thing, whenever you receive notice from some of the legal forum like consumer protection fora, then there is a stipulated time, and under Consumer Protection Act, you have to reply within 30 days, and maximum 15 days extra time may be granted to you under Consumer Protection Act. After that, it will be decided ex parte. Now, how to, what to do when you receive notice? First of all, whenever you receive notice, never get panic. It doesn't mean that you are held negligent. So never panic and never avoid receiving notice. If you people are avoiding receiving notice, they are not receiving. So that is not advisable. Somebody on receiving notice, try to communicate with the patient through some friends or relatives to settle the case. So that things are never advisable. And some may use some political or muscle power to settle the case, but that is never advisable. So whenever you receive notice, first of all, calmly read notice. What are the content of notice? Second, you have to reply the notice. Again, there are 2 schools of thought. One school feels that you should reply to the point, para-wise, and you should only write the denial, that I deny this, I deny this, I deny this, like that. And second school of thought believes that when you receive notice from patient or their advocate, you should reply in elaborative reply should be given. So you have to describe everything. So that the matter will end there and then. So there are 2 schools of thought, but we personally believe that whenever you receive notice from patient or advocate, you should not reply in details, but to the point, para-wise denial should be written. So that is our understanding. Now, how to whenever you receive notice from Consumer Protection Forum or any other forum, commission, that is State Commission, Human Rights Commission or Women Rights Commission or any council, then you have to reply it in detail. And reply should be to the point, and it is always to be on your letterhead. Point-wise reply should be done, para-wise it should be done, and as soon as you receive notice, before replying, you must take advices. Okay. So first of all, whenever you receive notice from the patient, You gather all the documents of the patient with you. You have a look into the documents. After receiving notice, you should not try to alter anything in the record because it will amount to a criminal offense. So you should not try to alter or add anything. If you want to add anything in the document, if you remember something, then by putting the date, time and sign, you can add something in the record, but you cannot alter the record. So gather your documents, have a look into the records that what are the drawbacks and what are the positive points for you in that record. After receiving that document, then you should take medical opinion from your senior person in medical field. Then legal person, you can select the advocate and take the legal advice. And as soon as if you have facility of medico-legal practitioner, you can take help of medico-legal person. Now, even before receiving notice, whenever you have apprehension of receiving notice from some patient or some incidents in your hospital, or if it is not so, then on receiving notice, immediately you should inform your insurance company if you have indemnity insurance, so that you can get the help of legal person from the insurance company also. After going into the document, after taking proper advice, you should start gathering the evidences, medical evidences in favor and against you. So why against you also? Because you may know that whatever will be produced by the patient, how to counter that. So we should know that. So we should gather all the medical references from our standard textbook, from the journal, from the published paper, or from some expert, that what is in your favor and what is in your against. And if the points are going against you, if they will be put, how will you tackle those problems? Same way, you have to select the advocate at this point, and you have to take advice of a legal person. Now, while taking advice of the legal person, you have to assist legal person, because legal person do not know what is medical science. So it is your duty to assist him, and he will get the reference of cases, decided cases by different courts. So the advocate will decide or collect the references in favor of you and against you, and how to tackle the cases which are decided against you. So that will be decided by lawyer. Now, how to select lawyer is an art. So we always recommend that we must select a lawyer after going through in details of the lawyer, that how many medico-legal cases he has defended. So the person who is acquainted with medico-legal cases should be appointed, first of all. Second, the person who is ready to hear you or answer your queries, or who is ready to give you time, then that is preferable. Third thing, how will you come to know that who has done the medico-legal cases or defended medico-legal cases? So you have to go through the judgment given by State Commission, that in CPJ, that is Consumer Protection Journal and Consumer Protection Reporter. These are the books where judgments are imprinted. So from that you can get the detail that who are the advocates who are appearing in medico-legal cases. From there you can get the knowledge. If somebody is friend or relative who is close to you, and if you feel that he will hear you and he will keep in touch with you, then it is advisable always to have an advocate who is very near and dear to you, so that he will definitely take your case personally. Always experienced person who is good, who is having good standing, that advocate is always better. So these are the things while selecting the lawyer you should keep in mind. Now, you can also by the side, because the advocate may not understand medical language and you cannot understand legal language. So there is now another creature nowadays known as medico-legal person. So he knows also medical science and as well as legal science. So he is one of the better person to represent you, but he may not be knowing the arti-booty of code. So it is always advisable to keep him as an advisor to assist lawyer. And whenever a case is filed against you, then you must involve insurance company along with your case. After taking all these things, your notice may end satisfactorily, so no progress will be there sometime. But if patient files a case against you after that notice, you can either compromise the case with cost, or it may be settled without cost. And if it turns into litigation, then a few things should be kept in mind, that you should take care that you should assist your lawyer, you should remain present with your lawyer in court, because whenever you present yourself, it makes difference in court. And you must take interest, and you must have a supervision on your advocate, that what he is putting inside court or what he is not putting. Otherwise, if you will not put your defense in the court of law, you cannot be saved. So these are a few things which we should keep in our minds.
Thank you very much, Keith, for so informative and in length. You have explained everything. So now I am very clear in my mind what to do. Thank you very much.
Thank you, sir. Thank you.